My name is Rob Collier. I'm with California Drivers Advocates, and today I'd like to talk with you about the issue of probable cause at a DUI hearing before the California Department of Motor Vehicles. If you've been arrested for DUI in California, you understand that there are two battles to be fought. One is with the criminal court to try to prevent a criminal conviction. The other is an administrative hearing with the DMV to try to prevent the suspension of your driving privilege. Here at CDA, all we do is the administrative part with the DMV. Now, when a DMV hearing officer is hearing a case, he or she must decide three things to be able to sustain the suspension of a driver's license. Number one, did the police officer have reasonable cause to come in contact with the driver, and then upon doing so, believe that person had been driving while under the influence? Number two, was that driver lawfully arrested? And number three, was that driver operating a motor vehicle with a blood alcohol concentration of 0.08 or greater? Today we're going to focus on issue number one, probable cause. Did that officer have probable cause to stop you or come in contact with you? So when it comes to issues of probable cause, the Constitution tells us that all of our citizens, and in this case drivers, must be secure in their persons, their homes, and their effects. And so for a police officer to interfere with that requires that they have probable cause to do so. In the vast majority of DUI cases that I see, drivers are contacted because they've committed some type of a moving violation. And this is a broad thing. This can be anything from running a stop sign, running a stoplight, speeding. And one of the things that we see most often is where the officer alleges that a driver was weaving, either within his lane or crossing in and out of lanes. So probable cause generally goes down to issues of driving behavior. Also, probable cause can be established if you've been involved in a traffic collision. And even though the officer doesn't see the driving, the law under Vehicle Code Section 4300.5 does permit the officer to make certain inferences if you were involved in a traffic collision, if your vehicle is blocking a roadway, and if you're near that vehicle. So they're allowed to make certain inferences about driving, which goes right to the heart of probable cause. Now, obviously, all of these things are subject to attack. If you're thought to have been speeding, we can look into that. If you are thought to have been weaving, we can look at dash cam videos to see if that's true. As to the presumption of involvement in a traffic collision, they have to prove that you were the driver. So there's many ways to fight probable cause, but you have to know what you're doing. If you've been arrested for DUI, if you think that there may be a probable cause issue in your case, give us a call. Run the facts by us. Let us answer your questions. We're here to help.